Hello everyone, I'm Debojeet and you're watching Courts Today by LiveLaw, your daily roundup of the major stories coming out of India's courts every day. The courts were as busy as ever, from national public health emergency to Patanjali's ongoing battle against Dabur. The docket is full today, and so without any further ado, let's begin. Starting with the Delhi riots larger conspiracy case, the courtroom once again turned into a battleground over evidence, delay, and what the defense called a manufactured narrative. Senior advocate Siddharth Luthra, appearing for accused Shadab Ahmed, told the bench that his client has been in custody since 2020, facing multiple FIRs tied to the riots, including those involving the death of Constable Ratan Lal and the burning of a Maruti showroom, yet has already been granted bail in all except this so-called larger conspiracy case under the UAPA. Luthra pointed out glaring inconsistencies in the prosecution's case, saying there are over 12,000 documents, no sanction under the CRPC, and that even the case diary is incomplete, missing pages and numbering. He accused the police of falsifying evidence and introducing new protected witnesses, named radium and sodium, years later to patch gaps in the story. Calling this a case of broad generalizations and speculative links, Luthra said prolonged incarceration under UAPA cannot replace a fair trial. The bench will now hear the Delhi police's response on Monday, but for now, the defense's message was clear. This is less about terrorism and more about punishing dissent. Staying with Delhi for this, as a public interest petition has been filed in the Supreme Court urging that India's worsening air pollution crisis be declared a national public health emergency. The plea points out that air quality levels, especially in Delhi and other major cities, routinely exceed safe WHO levels by 10 to 20 times, with an estimated 2.2 million school children in Delhi already suffering from irreversible lung damage. The petitioner accuses the government of responding with weak, fragmented, and largely symbolic measures, arguing that tools like anti-smog guns and mist sprayers merely create an illusion of action instead of addressing the real sources of pollution. It further flags serious gaps in air quality monitoring, describing them as critical data shadows. Experts have said India needs around 4,000 monitoring stations, yet existing systems are mostly concentrated in cities, leaving rural areas and vulnerable populations systematically untracked. The plea calls for a comprehensive time-bound national action plan, one with statutory authority, strict timelines, and enforceable penalties to combat what it terms as an escalating public health catastrophe. Moving on to the Calcutta High Court, which has asked the Election Commission of India to file an affidavit by November 18th, explaining exactly how the SIR process, or the Special Intensive Revision, is being implemented in West Bengal. The background is this: a PIL filed by petitioner Pintu Karar questioned the SIR exercise, pointing out that the revision is being done using data going back to 2002, not updated to reflect current voter demographics. The petitioner asked for an extension of the timeline and for the process to be supervised by the court. During the hearing, the Election Commission of India's counsel told the bench that because the previous SIR was held in 2002, voters already on the rolls don't need to submit fresh documents, and that the door-to-door verification by booth-level officers has already started. The court also flagged concerns about the safety of BLOs, or the booth-level officers, conducting field work amid reports of threats, though it stopped short of giving detailed directions on security. In a sense, the Calcutta High Court is pushing the ECI to show transparency and accountability in how the SIR is carried out in West Bengal, and to justify both the methodology and the choice of database here. This sets a tone that electoral roll revisions cannot proceed behind closed doors. Next, with the Madhya Pradesh High Court, we saw the petition filed by Shah Bano Begum's daughter, asking the court to halt the film Haq's release, claiming it portrayed her mother's life without consent and distorted personal and marital details. The court, however, dismissed the plea, saying the film is clearly labelled as fictional and inspired by the landmark 1985 Supreme Court case, rather than claiming it to be a factual biography. The court observed that since the film draws on publicly available court records and documents, the former right to privacy of Shah Bano has expired with her death, and her heir cannot object to its use in a dramatized narration. Because the film has already been certified by the Central Board of Film Certification and the petitioner had not used the alternative remedy of approaching the central government to suspend or revoke the certificate, the court found no merit in the case and cleared the film for release on schedule. In short, the court upheld creative freedom under the law, saying a fictional film inspired by real events does not require consent from heirs, especially when based on public records, and allowed Haq to hit theatres. From Madhya Pradesh to Gujarat, as the High Court today granted a 6-month suspension of sentence to Asaram, who was serving a life term in a 2013 rape case. The division bench made the decision noting his age, medical condition, and the fact that the Rajasthan High Court had earlier given him 6 months suspension on similar grounds. Asaram was convicted by a Gandhinagar Sessions Court for the rape of a minor in 2013 and has been in prison serving a life sentence. In handing the suspension, the High Court also asked the state to respond whether required medical facilities were available in Gujarat jail, pointing out that the Rajasthan court had cited lack of treatment facilities as a reason for previous relief. So while this does not grant full bail, it does give him temporary relief from his sentence for 6 months under strict conditions. Next, we'll take a look at an important update from the Kerala High Court, where the court was informed that the Bar Council of India has granted interim approval to add 2 supernumerary seats for transgender students in every government law college in Kerala for the academic year 2025-26, both in the 3-year LLB and 5-year integrated LLB programs. The court noted that while the BCI has approved the seats, universities must now formally implement the change. It directed the petitioner to include all relevant universities before the hearing and signaled that it may issue a general order to expedite the process. In other words, the Kerala High Court has taken a proactive step to ensure transgender students get dedicated seats in law colleges, pushing regulatory bodies and universities to move swiftly. Moving on to a conflict between industry giants Dabur and Patanjali, where Dabur has challenged a TV ad by the latter for its Chyawanprash, where the ad shows someone saying, "Chalo dhoka khao," and claims that Chyawanprash products are dhoka, meaning deceit. In court, Dabur's senior advocate argued that since Dabur holds around 60% of the market, calling all other Chyawanprash products dhoka was directly disparaging Dabur and unfair advertising targeting the market leader. Patanjali's side said that the ad was simply comparative advertising. That product is special, others are ordinary or less effective, and that does not mean that those other products are fraud. The court questioned this interpretation, pointing out that using the word dhoka crosses the line because it implies deception or fraud, and not just inferiority. They asked whether calling others' products dhoka is permissible and reserved orders on Dabur's interim injunction. So far, the dispute has been about how far comparative advertisement can go before it becomes harmful or misleading, especially when it labels competitors as not just inferior but fraudulent. Next, we have an important update from the Kerala High Court, where it directed that physiotherapists and occupational therapists who lack recognized medical qualifications must stop using the prefix doctor. It noted that a clear conflict between the Indian Medical Degrees Act of 1916, which protects the reserved use of the title doctor for those with genuine medical degrees, and the new competency-based curriculum for physiotherapy and occupational therapy, which had permitted usage of doctor in syllabus documents. The bench found that the Ministry of Health and Family Welfare had already issued a directive removing the doctor designation for physiotherapists in the 2025 curriculum because using the prefix without a recognized medical qualification would breach the Indian Medical Degrees Act. And to round it all off, we reach where it all started from. The Delhi High Court's recent order involving former Delhi University Students' Union President Ronak Khatri and the Delhi police. Khatri has claimed that he received a threat demanding 5 crore rupees from an international number allegedly linked to gangster Rohit Godara and sought police protection for himself and his family. The Delhi High Court, presided over by Justice Ravindra Dudeja, directed the police to expedite their decision on Khatri's security request. The court ordered daily visits by a beat constable to Khatri's residence for the next 2 weeks and asked the station house officer and DCP of Outer North and Special Cell to immediately act on any threatening calls. In essence, the court reminded the state of its constitutional duty to protect citizens' lives and insisted that this threat assessment not get delayed. The matter now rests with the police to evaluate the danger and provide timely protection. That brings today's segment of Courts Today to a close, but if you're interested in accessing detailed coverage of all the stories mentioned here, visit livelaw.in and keep following all our socials to stay updated with everything that is law. I'm Debojeet. Thank you for watching.